Today, let us consider one more problem under Mohammedan law concerning to the apostasy. Here, we have to consider what are all the effects of the apostasy on marriage, on the matrimonial remedies which will be arising out of the dissolution of marriage. So these things we have to consider under the apostasy. So we have to see what are the effects of the apostasy on the marriage, on the matrimonial remedies. So let us see the method of problem solving. Here, as you know that there is an international approved method of problem solving with regard to the any legal problem. That means here it can be solved either in the way of FIRAC or IRAC or ILAC. So this is the method in which the problems or legal issues can be solved. So this is the international pattern of internationally accepted method of problem solving. So here we are going to adopt only FIRAC. That means here this is the very simplest way of the legal problem solving, and probably you may see this problem solving even you can see under the commercial laws also. Here with regard to the problem solving is very much common, but there the steps are different. Here under the law, this method has been widely accepted, widely followed, even in the international law schools also. Here, as I was telling you in my all previous videos with regard to the FIRAC, what is meant by FIRAC? F means facts, wherein we have to project the facts, we have to simplify the facts which has been already given to us. So there is some illustration problems will be given to us. We have to simplify it. So that is the significance of the facts. So here on the basis of the facts only we can be able to frame the issues, and we could be able to analyze the issue and the provision of law. Then we can do the conclusion. So after the facts, after simplification of facts, next step is issue. That means whenever any facts has been given, the immediate the aspect, immediately what we have to do, we have to frame the issues. That means what is the difference between the plaintiff and the defendant. So we have to frame the issues. Then it is very much convenient for us to solve the issue. That means we can find out where is the exact the difference is there, where there is a dispute is there. Here number of things may be there, number of what you call differences may be there between the plaintiff and the defendant. Here where is the question of law, where is the question of fact? So that aspect we have to highlight under the issue. Then we have to go for the rule. Here, as I was telling you, rule means it is nothing but the provision of law. So with regard to the given facts, projected facts, we could be able to frame the issues. So with regard to the issues, which is the rule, which provision of law could be applicable. So here with regard to all these things, we have to do the analysis. In the analysis section, we have to discuss all these facts, issue, rule under the analysis section. Then we have to give the conclusion. So this is invariably in all my videos I used to say with regard to these steps. So here there is one problem with regard to the Mohammedan law, with regard to the apostasy. Here one Pushpa, a Hindu woman, embraces Islam and marries Rizwan, a Muslim. Later, she re-embraces Hinduism and marries Rajesh, a Hindu. without divorcing the Rizwan. Here, Rizwan wants to prosecute Pushpa for bigamy, advise him. So this is the problem which has been given with regard to the apostasy. Here, one lady Pushpa, what she has done, she is a Hindu woman by birth, and her name is Pushpa. She got converted to Islam. Later, after getting converted to Islam, she married a Rizwan, a Muslim. Later, she reconverted to Hinduism and married Rajesh without giving divorce to Rizwan. So, this is the facts. Here, the the plaintiff, being the Rizwan, he wants to file the case against the respondent or the defendant Pushpa. What remedy he is having? So these are the facts of the case. So on the basis of these facts of the case, we have to frame the issues. Here I used to tell you that you can frame one issue or more than one issue. Here, depending upon the facts of the case, you have to frame the issue. Here, this issue can be framed on the basis of the facts of the case. Here, whether respondents' change of religion, that is Pushpa, had brought about a dissolution of the marriage of the parties. So, this is the first aspect we have to analyze. Then, whether Pushpa marrying Rajesh, not giving divorce to Rizwan amounts to adultery. So, these are the two aspects. These are the two issues we have to solve with regard to the present problem. Here, with regard to this one, we have to look into the what is the provision of law will be applicable here. Here, the provision of law is effect of apostasy on marriage. So, this is the aspect we can we have to on this background we have to solve this issue. And section 4 of the Muslim Marriage Act of 1939 also, which will be applicable. And here there is some exception to this general rule of apostasy will be applicable to this problem. And with regard to this one, we have to refer the case law of Sarwar Yar Khan versus Jawahar Devi and Amin Beg versus Saman. So these are the two case laws where we can refer the aspect with regard to the apostasy, that is effect of apostasy with regard to the marriage. So here with regard to the apostasy on marriage, there we have to see the apostasy by husband and apostasy by wife. There are two things are there with regard to the apostasy, the effect of apostasy on marriage. Then we have to analyze these facts, issue, provision of law under the analysis section. So when we analyze the facts, issue and provision of law, this aspect will come under this aspect we can come across under the apostasy by wife. As I told you, there is apostasy by husband also will be there. So as per general rule, if a Muslim wife renounces Islam, the marriage is not dissolved. In other words, the apostasy by Muslim wife does not operate as immediate dissolution of the marriage. That means what happens? Still the marriage subsists. That means here, for example, any Muslim wife, she relinquishes Islam and she marries any other person from any other religion. Then by renouncing the Islam, her marriage will not get dissolved automatically. So for that one, she has to file a case under section 2 of the Muslim Dissolution Marriage Act of 1939 for the dissolution of her marriage. So that is the rule what we can see with regard to the apostasy by wife. So this will be applicable to the husband also. Here, if a Muslim husband renounces Islam, the marriage dissolves immediately. But section 4 of the Dissolution of Muslim Marriage Act of 1939 does not apply to apostasy by husband. Here, what happens? this is a little bit different with regard to the Muslim husband. So here it will not be applicable to the Muslim husband. So here the that means the marriage it dissolves immediately. If a Muslim husband renounces Islam, the very fact of the renouncement of the Islam, the marriage got dissolved, and Section 4 of the Dissolution of Muslim Marriage Act of 1939 does not apply to apostasy by husband. Okay, we are concentrating only with regard to the apostasy by wife. Here, with regard to the Muslim wife, she continues to be wife of a married under she continues to be wife of a Muslim husband married under the Muslim law. So this is the general thing we can see with regard to the apostasy by the Muslim wife. But this provision which will not applicable to the converted Muslim. So here with regard to the apostasy by wife, the general rule that if she even though she renounces Islam and marries the person from a different religion, the marriage will not dissolve automatically. She has to get the divorce, the judicial divorce from the court. So under Section 2 of the Dissolution of Muslim Marriage Act of 1939. But this rule does not applicable to the converted Muslim. So this is here in this case law we can see it is a converted Muslim only. Here Hindu woman, that is Pushpa, she is a Hindu woman by birth, and she got converted to Islam. Later she married Rizwan, and later re-embraces Hinduism and married Rajesh without giving divorce to Rizwan. So this is the fact. That means here Pushpa is a converted Muslim, and such converted Muslim wife renounces Islam and again re-embraces or embraces her original religion. Then the marriage dissolves immediately. That means it is an exception for the general rule where a Muslim wife she renounces Islam and marries some other man from the different religion. Her marriage will not get dissolved. For this one, this is the exception we can see. So for the first, so let us see with regard to the let us see these aspects analyzing the issues. So here whether the respondent's change of religion had brought about a dissolution of the marriage of the parties means here with regard to the first issue the answer is affirmative in nature. In other words, there is a dissolution of marriage. That means if any converted Muslim during her time of her marriage and she marries a person from Islam religion and later she gets converted to the same original religion where she belongs, and at that time her marriage it gets dissolved immediately. Suppose a woman she belongs to Hinduism and later got converted to Islam. She marries a any person from Islam, and she renounces Islam and she embraces Christianity. Suppose what will happen if a woman belong to Hindu, got converted to Islam, later she get converted to Christianity? What about the dissolution of marriage? Here the marriage will not get dissolved in this case. So here the condition is that a converted Muslim she renounces Islam, but she has to re-embraces her original religion only. Then the marriage gets dissolved. So here for the first the question, there is a dissolution of marriage. When there is a dissolution of marriage, what is the effect? So let us see with regard to what is the second issue. Here, whether Pushpa marrying Rajesh, not giving divorce to Rizwan, amounts to adultery. Here in the problem they have given bigamy, but it's not bigamy. we have to make it as adultery. Here with regard to the adultery, here with regard to this issue, the answer is negative, that there is no commission of adultery by converted Muslim wife by re-embracing Hinduism, marrying a Hindu. So it is appropriate to quote the decision of Amin Beg versus Saman. Here with regard to this problem, it is very much appropriate to quote the decision of Amin Beg versus Saman, whereby the court has held that a Mohammedan law, a wife's conversion affects a complete dissolution with her Mohammedan husband. The fact of such conversion is therefore a bar to a suit by the husband for restitution of even conjugal rights also. So here with regard to but with regard to the aspect of dower. So with regard to the aspect of dower, what was the stand here with regard to the dower? Whether here the Muslim woman she with regard to the Muslim woman, the marriage will not get automatically dissolved. But with regard to the converted Muslim, here there will be immediate dissolution of marriage, and the husband is prevented from even filing the restitution of conjugal rights petition before the court of law. But what about the dower? Suppose if the dower is pending, what about the dower means? We have to see the case of Sarvar Khan case versus the Banwari Devi. So here in Sarvar Khan case versus what you call here Sarvar Khan versus Jawahar Devi, not Banwar Devi, Jawahar Devi, where the court has analyzed in length with regard to the dower. So with regard to the payment of dower, so there the court has analyzed so many aspects. But whether we can analyze that the wife is at fault, whether she can get benefited by her fault. So the court has analyzed that the wife by her own fault she cannot get benefited. So what is the remedy available to the Rizwan means it doesn't have no remedy. So in this on this light of the what you call the provision of law, let us conclude the problem with regard to the this problem that the Rizwan doesn't have any remedy with regard to the filing the petition for bigamy as well as for the restitution of conjugal rights, but he can withhold any dower is pending payable to the to his wife. So that is the only remedy we can suggest to the Rizwan under this problem.